Legal dictation 400 words 5 seconds. Start. Learned counsel for the appellants would submit that there has been no fundamental breach of the policy conditions. In this context, we may profitably refer to the decision in C. Bharathama, wherein a two-judge bench squarely dealt with the absence of a permit and ruled that plying a vehicle without a permit is an infraction and insurer is not liable. In Lakshmi Chand versus Reliance General Insurance, the court was concerned with an order passed by the National Consumer Disputes Redressal Commission that had declined the relief to the petitioner therein. The insurer in the said case had taken the plea that the complainant had violated the terms and conditions of the policy, for 5 passengers were travelling in the goods carrying vehicle at the time of the accident, whereas the permitted sitting capacity of the motor vehicle of the appellant was only 1+1. The two-judge bench referred to Oriental Insurance Co. Limited versus Meena and others and expressed the view that in order to avoid liability, the insurer must establish that there was breach on the part of the insured. The obtaining fact situation is sought to be acquired with the factual score in the said case. In this regard, it is useful to refer to the bench decision in HDFC Bank Limited versus Reshma and others. The issue that arose before the court was whether the financier was liable to pay the compensation or it was the liability of the borrower. The tribunal had returned the finding that the duty of the financier was to see that the borrower did not neglect to get the vehicle insured, and therefore it was jointly and severally liable along with the owner. The High Court had concurred with the said conclusion. The court referred to Parnaya Kala Devi versus State of Assam and other that has dealt with the definition of the term owner as contained in section 230 of the Act. In this said case, the vehicle in question was under the requisition of the state of Assam under the provisions of law. In that context, the court was expressed that the High Court failed to appreciate that at the relevant time the offending vehicle was under the requisition of respondent state of Assam under the provisions of the Assam Act. Therefore, respondent was squarely covered under the definition of owner as contained therein.